Most people think estate disputes happen because somebody died without a will, but the updated Wood Stewart family matter shows us something much deeper. Even when there is a will, even when there are companies, even when there are trusts, even when there is wealth, a family can still end up in years of legal conflict if control, authority, documents, and succession are not properly structured and followed through. And that is the lesson I want every Jamaican property owner, business owner, and diaspora family member to understand today. This is not gossip. This is not about taking sides. This is a legal education moment. The family of Gordon Wood Stewart announced in June 2026 that differences arising after his death had been resolved, according to a joint press release reported by the Jamaica Observer. But before that public resolution, court records showed disputes involving executors, company control, board decisions, the will, and attempts to use court processes around the estate. So today, I want to break down the estate planning mistake that ordinary families make all the time. They think having documents is the same thing as having a completed legal structure. I'm Sophia Bryan, managing attorney at the Law Boss Firm. At the Law Boss Firm, we help Jamaican and diaspora clients secure ownership and legal authority over property and estate matters without chaos, delays, or unfinished legal matters. And today's topic falls directly into one of the biggest areas we educate on: family disputes over estates, what the law really says, and why documents must be handled properly from the start. Quick disclaimer: this video is for general education only. It is not legal advice, and I'm not commenting on the private merits of anyone's family matter. I'm using publicly reported information and public court documents to explain legal lessons that Jamaican families can learn from. Gordon Wood Stewart was one of Jamaica's most prominent business figures. After his death, public court records and news reports showed a complex set of estate-related issues. The Jamaica Observer reported that the family later announced that they had resolved their differences and were looking forward to the continued development of his legacy. But here's the important point: a public statement of family resolution does not erase the lessons from the legal journey, because the public records show how complicated estate administration can become when you have family members, companies, executors, trustees, beneficiaries, and major assets all connected. In one court of appeal matter, the court discussed the will, Gore Stew Limited, the ATL Group, board issues, and the distribution of interest in the ATL Group. In another Supreme Court matter, the court dealt with an application connected to a proposed red flag audit and whether the executors could proceed under the Trust Act. So let's talk about the mistake. The mistake is believing that estate planning is finished because a document exists. A will is important, a trust may be important, company documents may be important, titles, shareholding records, powers of attorney, probate documents, and filings may all be important. But documents alone do not protect a family if the legal authority is unclear, the assets are not properly mapped, and the process is not completed. This is where Jamaican families get in trouble. They say everybody knows what daddy wanted. The eldest child would handle it. We have the title somewhere. There is a will, so everything is fine. The company belongs to the family, so we'll sort it out. We don't need to deal with that right now. That kind of thinking is dangerous, because when someone dies, the issue is no longer just what the family remembers. The issue becomes who has legal authority, what assets are actually a part of the estate, what assets are held in trust, what assets are owned by a company, who has the right to transfer, who has the right to manage, who has the right to challenge, what documents must be filed before anything can move. That is why estate matters are not just emotional matters. They are legal process matters. Consequence of the mistake: when these things are not clear, families can end up stuck in legal limbo. And the legal limbo is expensive. It can delay property transfers, it can block sales, it can create family conflict, it can cause beneficiaries to distrust each other. It can force people into court. It can turn what should have been a clean succession plan into years of litigation. The law boss messaging is built around this exact problem. Jamaican and diaspora property owners do not just want legal work, they want clear ownership, authority, closure, and peace of mind. And the public steward related case shows why that matters. In the Court of Appeal, the court considered whether certain board action should be restrained pending appeal. The court ultimately preserved the status quo on the appointment of an additional director until the appeal or further order of the court. In the Supreme Court matter about the proposed red flag audit, the court found that the executors were acting as executors and not trustees for that purpose, and that they did not have standing under the Trust Act to bring that claim. The court confirmed the March 16, 2026 orders and granted the application to strike out the claimant's statement of case. Here's the lesson for ordinary Jamaican families. If the wrong person brings the wrong application under the wrong legal authority at the wrong stage of the process, you do not just lose time, you can lose money, momentum, and control. Let's make this practical. A lot of families think estate planning is about answering one question: who gets what? But proper estate planning and estate administration must answer several questions. Who owns it now? Who controls it now? Who has authority after death? What document proves that authority? What must happen before the assets can be transferred? What institutions must recognize the transfer? What happens if beneficiaries disagree? What happens if the property is owned by a company? What happens if the asset is outside of the estate? This is why we have a will is not the same as the matter is finished. In the Court of Appeal decision, the court noted that the will dated May 15, 2020 gave detailed directions about how certain companies were to be organized after death. The court also referred to the specific allocation involving the ATL group. That level of detail is important. But even with detailed documents, implementation still matters because the law has to deal with timing, capacity, authority, directors, trustees, executors, beneficiaries, and court procedures. For families with Jamaican property, especially those living overseas, this is where things often break down. Someone can assume they can act because they are the child. Someone assumes they can sell because they pay taxes. Someone assumes they can transfer because they have the deed. Someone assumes they can make decisions because the family agreed verbally. But Jamaican legal processes do not run on assumptions. They run on authority, documents, filings, and enforceable rights. The better way is to stop treating estate planning like a document checklist and start treating it like a legal structure. At the law boss firm, the better method is structured, outcome-driven, and focused on the proper sequence. Authority first, then transfer, then registration, with the matter managed towards completion. That means you do not start by saying, just draft something. You start by asking, what is the end result? Do you want your name on title? Do you want a grant of probate? Do you want authority to deal with the estate's assets? Do you want a trust properly created and funded? Do you want a property transferred? Do you want a family dispute avoided before it starts? Once the outcome is clear, the legal pathways become clearer. The better way, 5-part framework. Step 1, map the assets before death, retirement, sale, transfer, or succession. Identify what exists: land, homes, company shares, bank accounts, vehicles, family land, business interests, trust assets, property held jointly, property still in a deceased person's name. You cannot protect what you have not properly identified. Step 2, separate ownership from expectation. This is a major issue. Being promised something is not the same as owning it. Being the eldest is not the same as having authority. Paying expenses is not the same as being the registered owner. Living on the property is not the same as having title. Being named in a will is not always the same as having immediate control. You need to know what the law recognizes, not just what the family understands. Step 3, confirm legal authority before anyone anyone sells, transfers, manages, or assigns. Ask, who has the legal authority to act? Is there a grant of probate? Is there a grant of administration? Is there a power of attorney? Is there a trustee? Is there a company director? Is there a court order? Is there a registered proprietor? This is where many families make expensive mistakes. Step 4, use the right legal process. A trust issue is not always a probate issue. A company issue is not always a family agreement issue. A beneficiary issue is not always an ownership issue. A will is not always enough to transfer property without further steps. This is why proper legal sequencing matters. The law boss approach is not only chaos or piecemeal work, it is legal project leadership. A clear pathway, defined stages, proper sequencing, and end-to-end handling until the matter is actually closed. Step 5, finish the matter. Starting is not enough. A will sitting in a drawer is not completion. An unsigned transfer is not completion. A family agreement is not completion. A probate application that never finishes is not completion. A trust that is never funded is not completion. A property transfer that is never registered is not completion. The goal is not paperwork. The goal is clear legal authority, enforceable rights, and peace of mind. People who protect family wealth are not the ones who wait until there is a fight. They are the ones who structure things while they still have control. They do not say, my family will figure it out. They say, let me make this clear while I can. They do not leave loved ones with confusion. They leave them with authority. That is the identity shift. Estate planning is not about distrust, it's about protection. It is not about expecting your family to fight. It is about removing the conditions that make fighting easier. It is not about death, it's about leadership, benefits. When you handle your Jamaican property and estate matters properly, you protect more than land. You protect time, you protect dignity, you protect family relationship, you protect your business, you protect your children from unnecessary conflict, you protect the value of what you spent a lifetime building. And for diaspora families, this is even more, because if you live in the United States, Canada, the UK, or elsewhere, and your property or estate issue is in Jamaica, delays are not just inconvenient. They can become expensive, stressful, and difficult to manage from abroad. That is why structure matters. So here is your takeaway. Do not wait for family dispute before you get legal clarity. Do not assume a will, a deed, a family conversation, or a promise is enough. And do not leave Jamaican property, probate, trust, or ownership matters unfinished. Click the link around this video to book a free 15-minute evaluation call with the Law Boss firm, or comment boss and we'll tell you how to book a free 15-minute evaluation call. The Law Boss firm, Jamaican property, estate matters, clear next steps.